Hello, my name is Stephanie Hoffman. I'm an estate planning attorney with Melone Hatley, PC. I'm here to talk to you today about special needs trusts. I'm going to give you 5 tips. The first tip is know whether or not you need a special needs trust. Who qualifies? So, special needs trust is a special instrument created for people who need government benefits, and if they inherited any money or had any assets, they may not be able to take advantage of those government benefits. This could be a young child, this could be a working adult, or even someone who's nearing retirement. A true special needs trust is a standalone trust. When you see other estate planning attorneys, they may recommend that you create a special needs trust within your will. However, if you know that someone that you love is going to need a special needs trust either now or in the future, you should create a standalone special needs trust to make sure that the trust is fully funded and to make sure that the beneficiary gets the full access to everything that they need. Now, what differentiates a special needs trust from a revocable trust or a revocable living trust is that the beneficiary cannot directly access those benefits. They have to go through a trustee. A special needs trust is irrevocable and cannot be controlled by the beneficiary. In a testamentary trust for children, a trustee's duties are usually made according to the HEMS standard, HEMS, health, education, maintenance, and support. Those won't satisfy a special needs trust. The trustee has to have more broad duties to give the beneficiary any support they can have that won't disqualify them for government benefits. Say your loved one is seeing a special doctor who doesn't take Medicaid. A special needs trust can pay for them to see that specialist without disqualifying them for the Medicaid programs that they've qualified for. There's 3 types of special needs trust. There's a third-party trust, which is created by family or friends and funded by them either at their death or during their lifetime. Grandparents, parents, loved ones can all contribute to a third-party special needs trust. A first-party special needs trust, or a self-settled trust, is usually created when the person that is receiving the benefits of a special needs trust receives an inheritance that isn't put into a special needs trust for them, or receives some sort of payout, either from a disability settlement or from a personal injury lawsuit or even from the lottery. If they received that lump sum payment, they would be disqualified for certain government benefits. Now, a pooled trust is something that people with fewer assets can join. The benefits of a pooled trust is that typically the pool has millions and millions of dollars for the benefit of their beneficiaries. The drawbacks of a pooled trust is that it is managed like a corporation, and they might not have the direct interests of your loved ones in mind. There have been stories, of course, in Florida about failures of pooled trusts, but they are still, on the most part, a good, safe bet for people that have fewer assets for their loved ones in the future. My last tip is don't do this alone. You shouldn't just go to a website and create a special needs trust. You don't know exactly what you need for a legal standpoint to protect your loved ones in the future. You should contact an experienced attorney like myself at Melone Hatley, PC. I wish you all the best in the future.